Now, United Democratic Movement leader General Bantu Olomisa has described the final report into the Phala Phala farm matter as an engineered cover-up. ATM, meanwhile, condemned the acting public protector for having subjected the country to undue delays in announcing her verdict on the matter. The party and the official opposition, that's the Democratic Alliance, say they'll take the report on review. We're now joined by Benedict Piri. He's MD of Jurisprudentia Specialist Council. Benedict, good afternoon, and thank you very much for your time this afternoon. Now, there are quite a lot of technical aspects to get through. Let's just start with the finding on paid work. The acting public protector took us through the concept of paid work as per legislation, even quoting the Constitution on the need to give words in a statute their ordinary grammatical meaning. And then based on that, she found the president did not undertake paid work. What did you make of that finding?
I think the finding is unduly narrow in the context, of the mischief that it's aimed to deal with. I do not think that you can construe and in effect give a member of the executive an ability to participate in a business to the extent that the president does in his close corporation, which he's the sole member of, and say that because he doesn't pay himself any money, he doesn't underdo any paid work, and therefore he's allowed to run that business. I think when you look at the mischief that that provision is aimed to do, and if you look at the Phala Phala report of the independent panel, what the panel said was, if you're going to be in cabinet, then you don't have a job. And if you want to keep your job or other type of remuneration or business interests, then don't go into cabinet. And I think it's as simple and as clear as that. And particularly in a country such as ours, where corruption is a problem, I think the courts are going to have to weigh in on this particular aspect and give it the broader meaning that would, ensure that we don't have issues such as this, where members of the executive participate in businesses through structures that we may not necessarily understand how in-depth that participation goes.
So it means you would agree then with the Democratic Alliance in their statement where they say she relied on legal jargon or perhaps narrow interpretation of the law to clear the precedent in this instance, that perhaps they missed an opportunity to pierce through the corporate veil here and ascertain without a shadow of a doubt the exact status of the president or his role within the company.
Absolutely. I do agree with the DA on this particular one, that the public protector missed an opportunity to actually test what is the purpose of the Section 96 of the Constitution around any other paid work. Yes, she's correct to say that, what you usually do when you interpret words in a statute or in a contract or any other legal document is to give them their ordinary grammatical meaning. But their ordinary grammatical meaning arises within a particular context. So that word, I don't think anybody can say that any other person in cabinet is not allowed to have a job, but they can own a business and simply say that, because you own a business and don't pay yourself, you can do that, but you can't have a job. I think it makes no sense at all. And that jargon should actually be extended in the way that the Section 89 independent panel found.
Because if we were to take an excerpt, just the affidavit of the president, he stated that he had told Mr. Ndlovu on the 27th of December that he, along with the general manager, would process matters pertaining to the sale and then bank the money when he returns from holiday. And such could, maybe to the ordinary man, mean that such an individual is in fact involved or directly involved in the operations of that entity. Would that not be the case?
That's exactly the case. And, the public protector actually did find, her words were that initially the president did not tell us, the full extent of his involvement in the business. And she found that he actually is a lot more involved than he actually led on. Those were her words. But to make that same finding and still turn around and say, well, he was more involved than he initially led on, but actually it stopped somewhere. There was someone else who ran as general manager, but who's actually in charge of making decisions. It's not the general manager. She didn't tell us if the general manager got a delegation of responsibilities from the owner and the member of the closed corporation, which is the president. The only person who's got the legal responsibility for how that business operates, even though it's a separate legal person, is the president. And he's the only person who gets the benefit of the financial interest from the business. So if the business had to be wound up today and sold, that money would only go to the president. So I don't understand how she makes those kind of findings, at the same time says, well, we don't have a pay slip or evidence that he was paid any salary, therefore he should be off the hook. I think this is highly reviewable, and I think the fact that the Phala Phala panel found differently, I think it's perfect for the courts to actually weigh in on this. And I think it's just important for South Africa as a whole, for members of cabinet to know that they shouldn't be engaged in any businesses when they make it into cabinet. I think that's important for the country, given where we come from.
No, it will most certainly be a very important and interesting case to observe once it perhaps gets into our courts, and possibly many, as they say, might find its way even into the ConCourt. But Benedict, unfortunately, we've run out of time. Thank you very much for your input this afternoon. That was Benedict Phiri. He's the MD of Youth Prudential Specialist Council.